I'm Albert Leung, the moderator for the session. So I will just try to give a brief introduction on yourself before your presentation. So Mr. Chow has been recognized as a leading lawyer in China-related dispute resolution by various legal directories. He has been continuously ranked as a Band 1 international arbitration lawyer by chambers in recent years, received the award of Lawyer of the Year, Dispute Resolution / Arbitration from China Law and Practice in 2014 and 2015. Mr. Chow currently represents and advises clients on arbitrations in China, Hong Kong, Singapore, and other jurisdictions, as well as lawsuits before various people's courts in China. Mr. Chow has represented clients in over 100 arbitration cases on international sale of goods, joint venture, equity transfer, energy, mining, construction, real estate, and intellectual properties conducted under the CTAC rules, the Institutional rules, the Hong Kong IAC arbitration rules, ICC rules, etc. His clients are mainly multinational companies, foreign invested enterprises, private equity firms, large as well as private enterprises. The topic from Mr. Chow is proposed amendment of the arbitration law. Thank you, Mr. Chow.
Thank you for the kind introduction. I also wish to thank my old friend Christopher Toh for the kind invitation. My topic today will be on the proposed amendment of the PRC arbitration law. As some of you may be familiar with the PRC arbitration law, it's a law promulgated in 1994 and effective from September 1995. That means to say this legislation has been there for 27 years with no significant changes over the 27 years. So in the arbitration community in China, there has been a call for amendment for quite some years. But you know, the process was not quite fast. But eventually, the Ministry of Justice of China has taken the responsibility for drafting the amendment to the arbitration law. The ministry came up with a draft amendment in July last year, about 1 year ago, for public consultation. I'm quite sure that the ministry received many comments, written opinions from the arbitration circle. So you may wonder whether this proposed amendment will officially become law in the short period of time. The expectation is yes, because the current legislature, the National People's Congress, the term will expire in March 2023. So because the amendment of arbitration law is on the legislative agenda of the current legislature, so most likely the amendment will be passed before that. So that's the expectation. Today, I think I'm going to highlight some of the major changes of the proposed amendment as compared with the current arbitration law, which is 1994 PRC arbitration law. Indeed, there are many changes, but you know, for the sake of time, I think I'll just highlight 7, 8 most important ones. Let me start with the changes in relation to arbitration agreement. We all know the PRC arbitration law is taking a quite conservative attitude towards the validity of arbitration agreement. So one of the main reasons for this is that there is a provision in Article 16 of the current legislation saying that a valid arbitration agreement need to contain 3 elements, namely the intent to arbitrate, the scope of arbitration and a designated arbitration commission. So the requirement on designated arbitration commission is quite stringent, because if the arbitration commission is not clearly or correctly spelled out in the arbitration agreement, then there's a danger that the arbitration agreement will eventually be deemed as invalid. The requirement for a designated arbitration commission is also the reason why there is no ad hoc arbitration in mainland China. Under the proposed amendment, particularly Article 21, the requirement for a designated arbitration commission is no longer there. So that means to say, even if there is no correct name of the arbitration commission in the agreement, or even if the name is missing from the agreement, most likely the institution can still be identified through the relevant provisions of the proposed amendment. I'll give one example here. It's Article 35.3. It says where the arbitration agreement does not clearly specify the name, the arbitration institution, but the arbitration institution can be identified according to the applicable arbitration rules agreed upon by the parties, then the dispute shall be arbitrated by such a arbitration institution. Where there is no agreement on the applicable rules, the parties may conclude a supplementary agreement on the applicable rules or on the institution. In case no supplementary agreement can be reached, then the dispute can be arbitrated by the arbitration institution which first registered the case. As I said, even if there is no name mentioned in the agreement, then the parties, the claimant, may be at liberty to choose arbitration institution and get the case registered. In case, the two parties register the case at different institutions, then the institution which first registered the case will have jurisdiction. So that's a quite a liberal approach as compared to the rather conservative approach taken under the 1994 legislation. Another major change is about the status of foreign arbitration institutions. Well, foreign may not be a correct term, because in mainland China, Hong Kong International Arbitration Center or other institutions from Hong Kong may be deemed as foreign in the sense that only domestic or those institutions in mainland China are considered as domestic. Well, here maybe I should use the term international institutions. So under the current legislation, there's no stipulation on foreign or international institutions. The reality is, in 1994, the legislators, they never conceived the possibility of an international institution conducting arbitration in the mainland China. So that's why it's not stipulated in the 1994 legislation. However, in practice, we frequently see cases where the parties agree to have, for example, ICC arbitration in Beijing or Shanghai. So the status of such arbitration will be uncertain. Whether such award made through such proceedings can be enforced in China, there's also no certainty. In fact, there were challenges towards an arbitration agreement calling for ICC arbitration in Beijing or Shanghai, saying that, although there is arbitration institution which appears to meet the requirement of Article 16 on the designated arbitration institution. Those foreign or international institutions, they are not arbitration commissions in the sense of the PRC arbitration law, because arbitration commissions need to be approved by the Department of Justice at the province level according to some provisions in the arbitration law. However, this problem has been solved in 2016 by the Long Leader case. In that case, the Supreme People's Court deemed the ICC agreement calling for arbitration in Shanghai as valid arbitration agreement. Since then, it should be deemed that the Chinese arbitration market is wide open for international organizations. So the free trade zone in Beijing and Shanghai, they also introduced regulations to allow international institutions to set up representative offices in those free trade zones. So far, the Hong Kong International Arbitration Center, Singapore International Arbitration Center, ICC, and the Korean Commercial Arbitration Board, they all establish representative offices in the Shanghai Free Trade Zone. So the Shanghai and Beijing Free Trade Zone, they also allow establishment of a case management centers in those free trade zones. But so far only the World International Property Organizations have done so. The other institutions are more or less hesitant because of the lack of certainty in relation to the arbitration legislation. So the proposed amendments in Article 12 clearly aim to resolve this issue. It provides that the foreign arbitration institutions may set up offices in mainland China to conduct foreign-related arbitration business. The term used here, offices to conduct, clearly indicate those offices are case management offices, not merely representative offices. That means to say the foreign institutions, once they set up offices in mainland China, they will gain the national treatment, or those offices will be on the same equal status or standing as PRC arbitration commissions. One of the most important changes in the proposed amendment would be on seat of arbitration. So the current legislation does not have a clear definition of a seat of arbitration. However, seat of arbitration, as we all know, has carry many important legal implications. So the absence of a clear definition of the seat leads to many problems, uncertainties. One example is that the supervisory court cannot be easily identified. So according to international practice, the supervisory court, the court which can set aside an arbitral award, shall be the court of the seat of arbitration. However, according to the current legislation, the court that has power to set aside an arbitral award shall be the court where the arbitration institution is located. That means to say, for example, if HKIE-C is to do an arbitration in Shanghai, the seat of arbitration is Shanghai, then the supervisory court, through the Hong Kong perspective or international perspective, will be that the seat of arbitration, the court of the seat of arbitration. That means to say the Shanghai court. However, according to the mainland Chinese perspective, since the institution is HKIE-C, which is located in Hong Kong, the seat, the court that can exercise supervisory power will be the Hong Kong court. So you can see there's a conflict here. That's caused by the lack of a definition of the seat in the Chinese legislation. Another example is about the nationality of the award. And the nationality also leads to the legal basis for enforcement. For example, if ICC render award in Shanghai, let's say Hong Kong, then according to mainland Chinese perspective, the ICC is headquartered in Paris, France. Then the award will be deemed as a French award, which is enforceable in mainland China under the New York Convention. However, by international standard or practice, the ICC award rendered in Hong Kong, because the city is Hong Kong. So this award's nationality would be Hong Kong, China. So the enforcement in mainland China can only be under the mutual arrangement between Hong Kong SAR and mainland China. So in fact, the Supreme People's Court in China has changed the attitude towards such award in the past 5 or 6 years. Nowadays, ICC award rendered in Hong Kong will be enforceable under the mutual arrangement rather than the New York Convention. This is only the judicial attitude, the attitude of the Supreme People's Court. There's no legal basis speaking from the legislation. Here I have listed a few cases. I wouldn't go into details. If you are interested, you can take a look at these cases. Those cases witness the evolution of the attitude, judicial attitude towards ICC awards rendered in mainland China or in Hong Kong. But eventually, ICC award rendered in Guangzhou, that's in the Brentwood case, that's deemed as a PRC award, and also foreign related PRC award. So that's to be reviewed by the PRC court in set aside and enforcement proceedings. I said too many things about the problems with lack of a definition of a seat of arbitration under Chinese law. So what will happen in the proposed amendment? There will be at least 2 provisions, most notably Article 27 on the seat of arbitration. And other provisions, they refer to the seat of arbitration in order to identify the court, in order to identify the relevant arbitration commission, etc. Under this proposed amendment, the supervisory court will be the court of the seat of arbitration. That will be in line with the international practice. And the nationality of the award will be determined according to the seat of arbitration. The law applicable to the arbitral procedure, lex arbitri, is still not clearly provided, but the general understanding has always been that the law of the seat shall apply, so that would not pose a big problem. Let's take a closer look at what Article 27 says. It says for arbitration in China, domestic arbitration in China, the parties may agree on the seat of arbitration. If the parties fail to reach an agreement on the seat, then the seat shall be the place of the arbitration institution that administers the case. Okay, for foreign related arbitration, the seat of arbitration under Article 91.3 will also be agreed by the parties if they so wish. If there is no such agreement on the seat of arbitration, then the tribunal may make a decision on the seat of arbitration. So at least for foreign related arbitration, this practice of having the tribunal to decide the seat of arbitration absence in case there's the absence of a parties agreement, that's totally in line with international practice. Jurisdiction. Under the current legislation, the jurisdiction will be determined either by the arbitration institution or by the competent court. not by the tribunal. But in problem, the jurisdiction issue, particularly the validity of arbitration agreement, is always intertwined with some factual issues. However, the court or the arbitration commission, they are not in a good position to make finding of facts. So that's why, some institutions, they have a delegated power of decision-making on jurisdictional issue to the arbitral tribunal. CTEC has done so, BEC has also done so. So internationally, the doctrine of competence is the norm, meaning the arbitral tribunal will be having the competence to decide its own competence or jurisdiction. That's can be seen from ancestral model law, the relevant provisions. So under the proposed amendment, the doctrine of competence will be embraced. The arbitral tribunal is given the power to rule on its own jurisdiction. But before the composition of the arbitral tribunal, the arbitration institution may decide whether the arbitration proceedings shall further proceed based on the prima facie review of the evidence. And the arbitral tribunal's decision on jurisdiction is not final. The parties may, if they are not happy, they may go to the court to seek a review of arbitral tribunal decision on jurisdiction. So that's basically the ancestral model law approach. So by this proposed amendment, Article 28, CTEC, PRC arbitration law will officially accept the international practice with regard to decision making on jurisdiction. The arbitral tribunal panel system, under the current legislation, the law will require every arbitration institution to set up a panel system. And the panel system will be applied to cases mandatorily, meaning the parties can only choose arbitrator, a panel of arbitrators maintained by the arbitration institution. In practice, some institutions, such as CTEC, has accommodated some flexibility, allowing parties to choose arbitrators from outside the panel. So this approach has been accepted in the proposed amendment. According to Article 50.2, parties may select arbitrator from outside the panel of arbitrators, and arbitrators selected from outside the panel shall satisfy the criteria stipulated in the arbitration law. What does it mean? It means that, the PRC arbitration law always maintains some criteria for arbitrators. Although the arbitrators selected from outside the panel, from within the panel is no longer required. Those selected from outside the panel, they should meet the statutory qualifications of the PRC legislation. There are also some changes with regard to arbitration proceedings, and those changes would be introduced in light of the pandemic situation. Basically, there will be a clear provision allowing arbitration to be conducted virtually or online. And also, it is clearly provided that documents can be transmitted by way of electronic means, such as email. Another topic would be interim measure. Under the current legislation, only the court can order interim measure. Tribunal cannot order interim measure. Even arbitration institution cannot order interim measure. The measures ordered by the court basically include three categories, known as preservation measures. And those three categories are property preservation, evidence preservation, and conduct preservation. And the conduct preservation are basically more or less the same as injunctions and the common law. In the proposed amendment, the tribunal will be given power to order interim measures. They can order all three types of preservation measures. In addition, they can also order short-term measures that the arbitral tribunal deems necessary. That's in Article 43.2 of the proposed amendment. So this also is welcomed because usually the arbitral tribunal is in a better position to order interim measure or to evaluate whether interim measure should be ordered. Another big topic will be ad hoc arbitration. As I mentioned earlier, that Article 16's requirement on designated arbitration institution means that ad hoc arbitration will not be allowed in mainland China. In practice, many practitioners have been criticizing the conservative attitude in the current legislation, saying, ad hoc arbitration is widely accepted in the world. Why should we not have ad hoc arbitration? In 2016, the Supreme People's Court introduced a regulation which says that in the free trade zone, company registered in the free trade zone, they may arbitrate in specific locations with specific rules and by specific persons. Three specifics. Those actually refers to ad hoc arbitration, although they do not use the term ad hoc arbitration. In practice, I don't see many such cases because parties, they are used to institutional arbitration. In the proposed amendment, in Article 91.1, there is a provision saying the parties to a commercial dispute involving foreign related elements may agree on arbitration by arbitration institution or directly by ad hoc arbitral tribunal. So ad hoc arbitration will be allowed for foreign related cases at least. The door will be open. However, speaking for myself, I'm never a big fan of ad hoc arbitration. The reason is that, as I said, the Chinese institutions, they provide good services, and Chinese parties are used to such services. There may be cultural reasons. If you take a look at Taiwan, they also do not have ad hoc arbitration in practice. So the Chinese culture basically is that parties, when they are going to resolve a dispute, they prefer to do it through a established or bureaucracy, established institution or bureaucracy. So there's not quite much respect for individual decision makers. But anyway, that become history, and we will have ad hoc arbitration under the proposed amendment. In practice, there will be difficulties because the current attitude, current approach, I wouldn't say current, the approach taken by the proposed amendment is that in case arbitrator cannot be appointed, then the court, relevant courts will appoint an arbitration commission to act as an appointing authority. That's a very complicated procedure, and that means delay and also cost. And also, in recent years, there's a lot of debate about sham arbitration. Parties, or sometimes it's called hand-in-hand arbitration. And the claimant and the respondent, they cooperate with each other. They do not have a real dispute. And by going to arbitration, they may, more or less prejudice the interests of third parties. So the judicial attitude is against such arbitration for sure. But if it's institutional arbitration, the institution may keep a close eye on, friendly arbitration. But for ad hoc arbitration, how could such kind of a sham arbitration be under control? It will be a challenge. Another major change is about the grounds for set aside the arbitral awards. Previously, for domestic awards and for foreign-related awards, there are different grounds. I listed on this page the grounds for set aside foreign-related arbitral award. As you can see, no arbitration agreement, the matters are beyond the scope of arbitration, composition of arbitral tribunal is at issue, and respondent is not given sufficient opportunity to present his case. Those are all procedural grounds. And the court can also have an ex officio review based on violation of social public interest. That's similar to public policy and the common law. So those are the grounds, procedural grounds plus public policy. That's the grounds for review for in a case where foreign-related arbitral award is sought to be set aside. For domestic award, there are these grounds that I just mentioned are also valid grounds, but in addition, there are three specific grounds. One is award is obtained as a result of fabrication of evidence, and the other is that a party conceal evidence that is sufficient to affect impartiality of the award. Those are considered to be the substantive grounds for review of award, for judicial review of the award. And there's also a ground saying that arbitrators demanded accepted bribes, engaged in malpractice for personal gain, or perverted in law in making the arbitral award of the case. It's basically corruption. So these are the grounds for set aside. For enforcement under the current legislation, the grounds are basically the same. For domestic, it's the same grounds for set aside domestic award. For foreign-related awards, the ground for non-enforcement is the same as the ground for set aside the foreign-related awards. Under the proposed amendment, for set aside either the domestic or the foreign-related awards, there are uniform grounds are listed here. As you can see, most of the grounds are still procedural grounds. Among those grounds, there is one. It says award is obtained as a result of a malicious collusion, fabrication of evidence, or other fraudulent acts, which seems to be similar to one of the substantive grounds that I mentioned. So, so nowadays, the grounds for setting aside domestic and foreign-related awards, they are unified and basically procedural, with this exception on substantive issues. But this is not surprising. If you take a look at the English Arbitration Act, it also has a similar provision saying if the evidence is obtained by fraud, then the award can be denied enforcement. The most interesting change will be this. For non-enforcement, all the other grounds are get rid of. The only remaining ground is on public interest, and that's court's ex officio review. I think the rationale is that the legislature thinks, or the Ministry of Justice thinks, if the parties want to challenge an award, it can do so in the set-aside proceeding by invoking one or a few of those grounds. But if the party has not done so in the set-aside stage, then they should not be given the second bite in the enforcement stage. In the enforcement stage, the court, as the gatekeeper, they only look into the social public interest issue. And that's because the court assumes such a duty. I think that's the rationale. Well, I think I have finished my elaboration about the major changes under the proposed amendment. Basically, the proposed amendment will bring the Chinese arbitration law regime on arbitration in line with the international regime. There will no longer be major differences between the PRC arbitration law and the on-situ model law. Although I cannot say, PRC arbitration law and if amended, will be the same as a model law, or mainland China will be considered as a model law jurisdiction. I think I still have a few minutes. I'll prepare some figures on construction and arbitration. I understand today's event is on construction dispute. So this is the figures I found from open resources about the percentage of construction disputes resolved by the major institutions. Probably you are familiar with the figures of ICC and Hong Kong International Arbitration Center. But for mainland Chinese institutions such as BEC and CTEC, the percentage of cases, the construction cases among their overall caseload is about 10%. For BEC, it's a bit higher, 13%. That means to say a lot of construction disputes are resolved by way of arbitration in China. The CTEC annually handle 3,000-4,000 cases, and BEC handle 6,000, 7,000 cases. So 10% is a quite big number. So internationally, I think each institution handle more or less construction disputes. For ICC, it's over 20%. That makes sense because the FIDIC clauses has a arbitration clause calling for ICC arbitration. I think there are also topics on adjudication. So I have provided here some information about adjudication in China. Well, under the Chinese legal system, adjudication is not stipulated in the law. CTEC and BEC has introduced their adjudication rules a few years earlier, but not so many cases. I understand in CTEC there have been a few adjudication cases. In BEC, I have no idea. I do not have any figures there. So an interesting issue is that because adjudication is not clearly provided in the law and certainly is not deemed as a final. So if the party has a multi-tier dispute resolution clause, which calls for negotiation and then adjudication and then arbitration, would the adjudication procedure be a mandatory procedure? Or would the parties be allowed to bypass the adjudication procedure and go directly to arbitration? This is an interesting issue. I have found two cases. One is an arbitration case at Wuhan Arbitration Commission. That's a 2002 case. The other is a case, a court case. The court is Wenzhou Intermediate Court of Zhejiang Province. In the two cases, the decision are the same. It's deemed that adjudication is not a mandatory procedure. And if the parties can go to adjudication, they are free to do so. But if a party chooses to bypass the adjudication procedure and go directly to arbitration, the arbitration institution's jurisdiction or by international standard is called admissibility of the dispute would not be a compromise. They are afraid to accept the case and conduct the arbitration. That's I think because there's still a lack of understanding in the arbitration or in the legal community on the system of adjudication. That means to say there's a still need to further educate the practitioners, judges, as well as arbitrators about the importance of adjudication in resolving construction dispute in a quick and cost-saving way. If you take a look at other multi-tier dispute resolution clauses, in 2005 there was a case in which the court refused to recognize and enforce an arbitral award because the parties bypassed the negotiation period, the 45-day negotiation period. Since the 45-day is clearly provided there, so it means such a procedure carries more or less the mandatory nature. So the award was denied. But in some recent cases, the Supreme People's Court attitude is that if there is no clear period for negotiation or for mediation, then the parties are free to go directly to arbitration. Those are some cases I have found. I hope it's interesting. So that's why I'm willing to share it here. I'm finished. I finished the presentation here, and I'm happy to take questions from the floor.
Thank you very much, Lijun. A very informative talk on the proposed amendments, and we look forward to the enactment of the arbitration law. We have received one question from the audience and would like Lijun, your view. The question is, if the contract touches on Chinese law, do we need a local Chinese lawyer to be present at the arbitration proceedings? Can a foreign lawyer represent clients throughout in mainland China arbitrations?
Yes, I assume this question is about arbitration in mainland China, right?
Yes.
If it's also mainland China, certainly there will be no such restriction, no such problem. If it's arbitration in China, say as CTEC, and the applicable law is foreign laws or international conventions such as CISG convention, then the foreign lawyers are free to represent their clients without involving any local counsel and argue the case at a hearing. But if the PRC law applies, then the international or the foreign lawyer need to be careful. It's better to either bring a Chinese lawyer as co-counsel, or you can acquire a legal opinion from a Chinese law expert, for example, from a professor in advance of the hearing, and present the expert report to the tribunal. So the only restriction, I think, is from a very early regulation by the Ministry of Justice, 2002 or 2003. I do not remember clearly, but around that time, the restriction is for foreign lawyers not to, not to interpret PRC law issues. So if you bring a co-counsel to do the interpretation work of you, or you get opinion from a Chinese law expert, then that will be fine. There is no such restriction whatsoever in the CTEC rules or in the BEC rules or in any other institutional rules on foreign lawyers' role as counsel in those proceedings. Hope I'm clear on this.
Okay. Thank you very much, Mr. Chow. And again, thank you very much. And we look forward to your coming to Hong Kong and meet us face to face. And meanwhile, may we thank Mr. Chow in the usual way.
Thank you.
Thank you. Thank you.
Bye.
Thank you.